Well, good morning, ladies and gentlemen. It's a delight to be with you. I'm so pleased to see this many of you this early in the day. It's also great to have not only a Mancunian audience, but an international audience, a la Felix. So thank you all for coming. Now, Tatiana has told me this is being recorded. So if I have a short marriage one day, you can all troll me. Let me start by telling you a bit about myself and the work that I do. I'm a barrister at 4 to 5 Grayson Square. That means I get to wear a wig and gown from time to time. I work in civil litigation, including Talata and trust matters, for those of you who deal with that. There's some commercial work, housing, and property. I also, of course, work in financial remedies. Now, one of the strengths of having a more broad practice is that it's helpful where issues overlap. For example, I had a case not long ago where the parents were fighting over the children, as one does, and the father wasn't too happy when the court found in my client's favour. So there were rival possession proceedings taking place, with essentially the father trying to dispossess the mother of the home, move in himself, and circumvent the family order. It's really useful to know that background and to have been in the room when you then go to the possession proceedings and tell the judge, by the way, this is exactly what the family court was concerned about. It gives you that much more clout. And as I say, it's useful when there's a concentration of issues. I always think of your firm when lay clients approach me, because I know that you're the premier set when it comes to divorce. And Jemima's instructed me in a case that's taking place in a few weeks. So I look forward to working with many of you. I know that your cases are usually big money cases involving KCs with a bit more grey hair than myself. I've worked as junior counsel with Jacqueline Perry KC as well as Philip Sapswood KC at my chambers, and both are mighty. So if you do need a team, my chambers can certainly provide. Let's now turn to an overview of what we'll be discussing today. I'm going to be asking 3 questions. What is a short marriage? What factors will the court consider? And finally, what in particular is the impact of premarital cohabitation? Now, some of you, when you think of short marriages, might be thinking of Britney Spears and Jason Alexander, who famously married for 2 days and then had it annulled. I think Las Vegas was the venue, but I will stand corrected by the more informed among you. There is case law on such short marriages. The case of Christman and Christman states that the court may order no financial provision in marriages of an extremely short duration. So if any of you marry and divorce after your famous Thursday night soirees, you can be assured that you won't be out of pocket. There is no formal definition of a short marriage, but there are benchmarks. The median marriage in the UK is 12 years, and the most common mode is 8 years. So we can use those kind of items of information at our disposal when making the case to the court about whether something is or is not a short marriage. I fought a case not long ago where the parties had been married for 18 months. I think we can all agree by these benchmarks that that would qualify as a short marriage. So what are the factors that the court will consider? Well, you'll be familiar with these factors, the Section 25 factors under the MCA. The court's priority, of course, will be the welfare of children under the age of 18, and thereafter, in no particular order, the courts will consider resources, needs, standard of living, age, marriage's length, any disabilities, parties' contributions, any benefit either party loses from divorcing, conduct in exceptional cases, and ultimately whether to make an order for a clean break. Finally, and most vaguely, the courts will consider all of the circumstances in the case. And that comes from the case of Miller and Miller. So the slides should give the citations for any cases you need, but I can also send around an article I wrote on this to anyone that wants it. So what are the 3 elements that will be considered as per Miller and Miller? Any guesses? Needs? compensation for relationship-generated disadvantage, and sharing the fruits of the marital partnership. Now, here we have a photo from the film The Awful Truth, and for any Cary Grant fans among you, as per the opening slide. And yes, the dog was the main issue that they were fighting over when it came to divorcing. If only life were that simple, ladies and gentlemen. So the question is, where does this leave someone who's divorcing after a short marriage? Well, non-matrimonial property will rarely be shared unless it's been placed in joint names or changed into a different asset. And of course, that's less likely to have taken place when people have only been married for a few years. As for children, they will still be considered as a paramount factor, even if it's a very short marriage. So that meant that in the 18-month marriage case I told you about, where in fact there was a child from a previous relationship, the judge still considered that child's needs, and that factored into housing needs. What about the other needs, disabilities, and standard of living when it comes to a short marriage? Well, since the case of White and White, which I'm sure you all know about, the courts have been disposed to interpret needs generously. So if you consider that there was no financial provision in Kreisman and Kreisman, where they lived together for 2 weeks, we're going to be balancing that against the possibility that the judge, in a short marriage, but not an extremely short one, will still want to be generous. And this is why so much turns, ladies and gentlemen, on the character of the judge that you have, which is something we always say in law, but which is especially true in family cases. Finally, the leading case of E&L, which is recent law from 2021, states that it is discriminatory for childlessness to make a difference. You see, the court was questioning the logic of focusing on whether a family's assets were accrued in a short or a long marriage. So we see how the judicial logic continues to evolve, sometimes even in the course of a hearing. We turn then to the final aspect of talk. What is the impact of premarital cohabitation? In the case of CO and CO, Coleridge J, bless you, included 8 years of cohabitation in his analysis, as well as the 4 years of marriage. That's very interesting because, especially in the modern day, quite a lot of parties, I'm sure you'll find, have cohabited for years before the marriage took place. So if you're representing the person bringing the application and you want to make this overall relationship seem that much longer, cohabitation is going to be vital. In GW and RW, Moiston J held that it's unreal and artificial to treat a period of cohabitation and one of marriage any differently. And I can tell that some of you are already doing the arithmetic for your own relationships. Court's approach, again, proved vital in the case I described, my 18-month marriage case, because the parties, while they'd been married a short time, had lived together for about 3 years. The court therefore construed this overall as a 5-year relationship, which was that much more advantageous for my client. Overall, the lack of precise guidelines in this area means that there is some flexibility, and so it's going to be that much more important for keeping the judge on side. I did a case where one party tried to downplay the extent of cohabitation. The judge was unimpressed, and it reflected in the judge's order. So I think that degree of we're not allowed to coach our witnesses, but that degree of instruction to our witnesses beforehand about the need to be calm, to be consistent, and to ensure they don't antagonize the judge will really make a difference in these cases. I'm sure many of you are enjoying the cartoon here. Let's zoom in on the question of the principles to consider in light of GW and RW. The approach in this case has become accepted. So what counts as cohabitation? Well, Kimber and Kimber, which is an earlier case, shed some light on this matter. Courts will consider whether the parties share daily life, whether they have joint finances. It will even entertain the question of whether they had a sexual relationship. So you can see the full gamut of factors at play for a court. As I mentioned, the law in this area is such that it continues to evolve. The court in 2019, the case of X and IY, was cautious. They held that the mere fact the parties begin spending time in each other's homes does not equate to marriage. I can see one gentleman looking relieved. More recently, the case of VV and VV, very memorable on account of its name, it clarified that cohabitation does not require spending every night together. So whatever the circumstances, you're going to want to try to pitch it to the court as a long-term relationship encompassing marriage and cohabitation alike. But that's not to say cohabitation is a silver bullet. 2017's case of Sharp and Sharp, the Court of Appeal stated that a short marriage, whether with no children or mixing of assets, might justify departing from the principle of sharing the family's fortune. So what we're looking at is the fact that someone in a short marriage is probably in a weaker position as a result of making less of a financial contribution. The reality check for your clients is to consider whether those who've been in a short marriage should ultimately be litigating. How much wealth have they accrued together in that brief period of time? In the 18-month marriage case that I mentioned to you, each party retained its own pension, showing the reluctance of the court to intervene that far when all the years in which they'd been earning their pension money, they hadn't even been together. On the other hand, in the same case, the judge was willing to divide the rest of the money between the parties to ensure they could both achieve their housing needs. So you can see how needs will be a dominant factor for the court in these cases. If there's little money involved, the clients would be well advised to settle and avoid protracted and costly litigation. But this is an area, as I've described, where there is scope for flexibility. Some judges focusing on needs and others being less generous when there are no children or mixing of assets. Ladies and gentlemen, you've heard what's at stake and you understand what can be achieved if you can emphasize cohabitation. I'm delighted to have addressed you, and please do let me know if you have any questions.